Okay.
All right. So I want to welcome everyone to the Know Your Rights as a person with a disability. My name is Danny Perry. I'm the Director of Community Engagement for Independence Care System. This workshop is brought to you by ICS's Health Home Program, the New York State Division of Human Rights, and Center for Independence of the Disabled, New York, also known as CIDNY. Just a little bit about ICS's Health Home. The ICS Health Home Program is not a place or a residence. It's a program providing additional services above and beyond what individuals receive from the long-term care plan to support their health and well-being in the community. The Medicaid-funded program is the first and only one of its kind in New York State, specializing in serving people with physical disabilities. To learn more, call 646-653-6230. Or you can email communityengagement@icsny.org. You could also visit us at www.icsny.org. As noted previously, closed captioning is available. To activate closed captioning, click on the closed captioning button at the bottom of your screen, or the up arrow to the right of the closed captioning button at the bottom of your screen. A small menu will appear. You then click on the show subtitles to turn on the captions. Click hide subtitles to turn them off if not needed. All right. So a couple of household items before we get started. We ask everyone to please mute yourself for now. Obviously, when we're doing the Q&A, you have questions, you can unmute yourself. You do that by going to your image in the upper right-hand part of that and just can toggle back and forth from mute to unmute. All right, we recommend using the speaker view, which can go back and forth between the gallery and speaker view. That'll allow you to be able to more clearly see the person who's speaking, and in this case, the presenter's slides. Feel free to use the chat box to ask questions. We will be monitoring that, and so we could ask the presenter questions through that way as well. All right. Before we get started, just a quick disclaimer. Please note that this workshop will be recorded. By taking part, you are consenting that ICS or our partners may reuse and distribute the recorded material. So with me today, we have Margie Trapani. She's the education director from CIDNY. And we also have John Herrion, the New York State Division, from the New York State Division of Human Rights. He's the director of disability rights. Margie's going to come on and briefly talk a little bit about the work that CIDNY's doing in a couple of key areas. And then from there, we're going to pass it along to our main speaker, John Herrion. Okay, so I'm going to stop sharing my screen now, and I'm going to hand it over to you, Margie.
Hi, everybody. It's great to be with you today. I think you're going to really have a good learning session with John Herrion. He's a terrific speaker, and it's great information. I just wanted to mention two programs that we're involved with that I'd love you to think about becoming involved with. The first is the 2020 census. I don't know if you can show me whether you've received your census and filled it out. Anybody? Anyway, yes, okay, somebody has, good, excellent. If you haven't either filled it out or received it and you're curious about it, want to know more, after the workshop, ICS is going to send out a fact sheet from us that includes information on how to reach out to us if you want help filling out your census or to understand it better. There are lots of issues, I know. One of them is that a lot of resources and budgets are going to be decided in the next several years that are going to affect us as people with disabilities. And if we're not counted, we don't have the influence to make sure that we're represented in those resources. So I want to encourage everybody to think about things like whether they have enough accessible, affordable housing, accessible transportation, education and training opportunities, good health care, and whether you feel like you're represented well at the local, state, and federal level. If you don't have all those things, the census is a good way to make your voice heard, along with all of the other advocacy we're all doing every day. I've filled out the census. A colleague of mine who's blind has filled it out, and I would tell you that it's pretty easy. There are a couple of things you need to know that you need to have available when you fill it out. It'll be on the fact sheet. And there are lots of protections about the data that you give the census. It's protected by federal law, and it's never attached to your name. On that sheet will be our census manager's email, plus our website segment for the census. So please take advantage. Let us know if you have questions, and please reach out. We'd also love to know if you filled out the census, so you can just shoot us an email and say you have, or put it on our website. The other program that I think is really important is a program called All of Us. I know the last time I was at ICS, I spoke to you about this. And it's a research program on health behaviors and futures. And I think you're all really well aware that every time some new treatment is discovered or developed, very rarely are people with disabilities included in how they do testing on it or how they understand it to be used. So this is our opportunity to be part of research for future healthcare treatments and medications. And also to put our stamp on the need for accessibility in healthcare. It's a 10-year program. You don't have to commit to a lot of things. And it's somewhat described in the sheet that's going to be sent out to you, but I've given you access to their website and to my email. You can contact me if you have more questions about it and want to know more and don't want to look it up on the website. I'm happy to talk to you. So that's about all I have. I just wanted to let you know about those programs and the access you have through us. And I would like to say I'm really delighted that John Harrion is here to talk to us about understanding better our rights and what the Division of Human Rights can do to help if there's a problem. So John.
Thank you, Margie, and thank you, Dan, and thanks to ICS and to CIDNY for having me this afternoon. Really appreciate these opportunities to connect with you all and the communities you serve. I'm going to share my screen here. And hoping you can all see the slides. So my name is John Harrion. I'm the Director of Disability Rights for the New York State Division of Human Rights. In that capacity, I assist with doing outreach and education on the state human rights law and the protections that exist for people with disabilities. I also do a lot of work internally with our investigators and prosecutors who handle these cases. So what I'm going to be speaking about today is the human rights law, coverage of persons on the basis of a disability. We had a record number of amendments to our law last year, and I'm going to touch on some of those as well, some of the changes that happened to our law, all of which increased protections for a number of individuals, which is a good thing. I also want to talk about how we enforce the law, how to file a complaint, how complaints are investigated, how cases go to trial, and then what kinds of relief and remedies can be awarded. Last year, we got over 6,000 complaints alleging various types of discrimination around the state. And if we look at the types of complaints that are coming in, over a third now are complaints that allege discrimination based on disability. So both race and disability really are the primary areas that we're seeing complaints come in and areas that we're focused on. It's very easy to file a complaint with our agency. You can do it via mail or email. You can fax it in. You can go to our website, which is there on the screen, www.dhr.gov. www.ny.gov/complaint. There's also a phone number you can call, 888-392-3644. And really, I want to emphasize that we are open for business. So even though, people may not be in the offices necessarily, we're all working remotely. We are taking complaints, we're investigating complaints. Those complaints are getting assigned to investigators, and the process is ongoing. We've waived the notarization requirement and are accepting complaints that are not notarized, and we can resolve those at a later date. So we're not forcing people to go out and get a notary to verify their complaint. As I mentioned, we take complaints over the phone, and certainly if an individual with a disability needs accommodation, whether it be a sign language interpreter, materials in alternative format, whatever the accommodation is, we are willing and able to provide it to make sure that individuals are able to communicate with us and to file complaints. There's no filing fees. You don't need a lawyer. So, you could file a claim in state court. You have either option is available to you. But if you come to the Division of Human Rights, there's no fees to file, and you don't need a lawyer. We have a unit that's staffed with prosecutors that prosecute these cases. If you go into court, which you certainly could, there'll be filing fees, and you really should have a lawyer to proceed in that way. You have up to 1 year from the date of the alleged discrimination to file a complaint with the Division of Human Rights. If that timeline, that time frame has expired, you do have up to 3 years to go into state court. You cannot do both, so you have to choose where you want to file. So if it's within 1 year and you want to file with the Division of Human Rights, we'll take the complaint. If you've missed that window, you can go to the state court to also file. So what happens next? I've filed my complaint. What can I expect to happen? Once the complaint gets filed, it gets assigned to an investigator. The complaint gets served on the party who's alleged to be discriminating, and they're required to file a written response to those allegations. Complainant will see that response and have the opportunity to rebut it. So in essence, complainant gets 2 bites at the apple in order to clarify and provide information about what happened. I oftentimes get asked whether or not a complaint can be filed anonymously. We do not take anonymous complaints. However, we do have a unit which is called the Division Initiated Investigations Unit, and that unit is dedicated to investigating cases that involve patterns or practices of discrimination. So if there's a large employer in your community, there's a large housing provider in your community, and they seem to be engaged in discrimination in a routine or pattern or practice form, you can alert our agency to that, and we have a unit that is dedicated to addressing those impact discrimination pattern and practice type cases. A big takeaway from today, I want to make sure people are aware of this, is that covered entities are prohibited from retaliating against complainants and other individuals related to the complaint, such as witnesses. So what does that mean? What it means is that people are reluctant to file complaints. They may not want to file a complaint against an employer or against their landlord. Again, a takeaway from today is that covered entities, employers, landlords, housing providers, businesses that are open to the public, are prohibited from retaliating against individuals because they filed a complaint. So, if there is a reluctance to file, you have anxiety, I don't want to, file this complaint and lose my job. I don't want to file this complaint and be threatened with eviction, but I know I'm being discriminated against and I want to remedy that. You're protected by law not to be retaliated against for filing the complaint. Another part of that is the underlying complaint can completely fall apart. We may find that there was no merit, that the housing provider wasn't discriminating against you because of your disability, or your employer was not discriminating against you because of your disability. However, when they threatened you with eviction or when they fired you because they received a copy of the complaint, that conduct is unlawful, and we can put them on the hook for that. So we hope that that diminishes the anxiety and the reluctance people may otherwise have to file complaints, knowing that they're protected from unlawful retaliation. And that also extends to witnesses. So, in a housing case, asking your neighbor, maybe the neighbor witnessed something or heard what was going on. and the neighbor says, no, I don't want to get involved in that. I don't, I have enough problems. Letting them know also, or a coworker know, that they're also protected from any kind of retaliation is an important takeaway for today. So investigators have up to 180 days to complete their investigations. In housing, it's actually 100 days, but for an employment or public accommodation case, it's 180 days. Once that investigation is complete, the investigator is responsible for making a determination of probable cause or no probable cause. Probable cause doesn't necessarily mean you win, Mr. or Mrs. Complainant, but it means that the case will go forward to a public hearing. A prosecuting attorney will get assigned to the case, and it will move along in the process. The means of doing the investigation include interviewing witnesses, looking at documents, all the information that a complainant or respondent wants to share with us, gathering all of that information and making a determination after reviewing it is what the investigator is responsible for. So if you get to a hearing and you're in front of an administrative law judge, you have your prosecuting attorney there. Hearing is held. There's a testimony, sworn testimony. A record is kept of the hearing. There are evidence admitted into, there are exhibits admitted into evidence. And after that is all done, the administrative law judge makes a recommendation as to whether or not discrimination occurred. And if there is a finding of discrimination, these remedies are available. These remedies would be available to any state or federal court judge. They are equally available to our agency as a law enforcement agency. And by statute, we have the authority to enforce these remedies. So certainly stopping the discrimination, would be first and foremost. If somebody was denied employment or was denied housing because of their disability, because of unlawful discrimination, that would be awarded. Oftentimes, when it comes to disability, we're talking about reasonable accommodations to do one's job, or reasonable accommodations to use one's home. They may be awarded. Compensatory damages, providing somebody with compensation because of the mental anguish that they suffered due to the discrimination they faced, or maybe loss of wages. They were qualified for the job or the promotion and they didn't get it because they were disabled. Compensating them for any lost income is also a remedy that's available. And the law has teeth to it. So civil fines and penalties, attorney's fees, are all available, and certainly in cases where there is egregious discrimination, assessing a civil fine or penalty can be done, an award of attorney's fees, and of course, ensuring mandatory compliance with the order is also a part and parcel of the remedies. At this point, I'm going to transition into some of the requirements in the law. But Danny, I'm happy to open it up for a couple of questions, a question or two. If people have questions about the process or questions about filing the complaint or what to expect. So I'm happy to open that up now, Danny, if you're able to do that.
You're muted, Danny.
We don't hear you, Danny.
Unmute.
You're muted. You're muted.
Yes.
Now,
No.
Can you hear me now?
Yes.
Yes.
Yes, I'm sorry. So anyone who has a question, just please unmute yourself and you can ask the question. Just looking in the chat box, there was a question about the presentation, if an individual can receive that afterwards. And yes, we're going to be sending out this presentation along with some material that Margie had discussed earlier. We will also be sending the recording of this presentation as well. We'll just need a few days to get that together. But separate from that, any other questions in regard to what John presented on, feel free to ask.
Okay, hearing none, that's fine. I'm going to share my contact information with everybody at the end of the presentation. So certainly as I go through these different topics, feel free to ask, but you can also reach out to me, at a later point in time if you want to, if you have questions about the law or about the process. I'm happy to answer those. So when we get into the, what are the, who's covered, right? So I have a disability. Am I covered by the law to be protected against discrimination? So here on this slide, there's a lot of words. It's the statutory language that is included in the definition of disability. And the takeaway here is that this definition has been very generously and broadly construed by the courts. Very rarely do we get hung up on how disabled somebody is. We are more so focused on whether or not discrimination took place. And we're allowed that because of the nature of the definition here in front of you, being very broadly and generously defined. It speaks to physical, mental, or medical impairments resulting from any number of conditions that prevents the exercise of a normal bodily function, etc. Having a record of an impairment. So this became clear to me when we were doing a program for people who were born with HIV. They were young adults and they had lived their whole life. And with the medical advances that had taken place, treatments and care, the quality of their life was very good. But if they disclosed or there was a disclosure as to their HIV status, many of them had terrible stories about harassment or discrimination that they faced because of that disclosure. So even though they may not have subjectively considered themselves as people with disabilities, having a record of that impairment also would cover them, and they would also be protected against discrimination. We don't get very many cases, but sometimes there's another bullet there at the bottom of the definition. Somebody may perceive you to be disabled based upon some stereotype or stigmatization or false information. And if they take an adverse action against you based on that perception, you can also be covered in that way as well. So again, very broad definition of disability. A distinction I want to share with you here is the one that exists between state and federal law. So most of you are familiar with the Americans with Disabilities Act. FHA stands for Fair Housing Act. Both of those are federal laws, and both require the individual, the disability, to substantially impair a major life activity. We don't have any such qualifiers under the state human rights law. You don't see the word substantial. You don't see the phrase major life activity anywhere. Again, there's not that level of scrutiny under the state law that there is under the federal law. So choosing where to file a complaint can be very important. Maybe you have a disability that's not that substantial. Maybe there's some question as to whether or not it affects a major life activity. You don't want to get hung up in a situation where you're not covered by the law if you think you face discrimination. And when it comes to disability, really the state human rights law is very generous in that regard. So that's something to keep in mind. I wanted to include that gender identity was added as an explicit protected class in 2019, so that people who have assert a certain gender or identify with a certain gender, that any type of discrimination that's based upon that is prohibited. And as you can see here from the language, we're talking about gender identity being defined as a person's actual or perceived gender-related identity, appearance, behavior, or expression. So again, very broad coverage there, and gender identity is covered as an explicit class under the law. Previously, we were able to cover it under sex and sometimes under disability, certainly under disability when the impairment was related to gender identity, such as gender dysphoria. And that would have been considered unlawful if somebody was being discriminated against because they were experiencing gender dysphoria, which is a diagnosable condition. That was unlawful on both the basis of gender identity and disability. So that's a recent change to the law I wanted to share with you all. We cover temporary disabilities. So somebody who has a condition that's temporary, you're also covered by the law. But in those instances, usually the need for accommodation is minimal. And typically the example is, a reasonable amount of time away from the office or away from work to recover from the temporary disability, but they're covered as well. I want to talk first about employment. The majority of the complaints that we get at the agency, over 80% of the complaints that we get at the agency are complaints alleging employment discrimination. We cover all employers in the state of New York. It used to be 4 or more. This is another change that was made to the law last year. But now we cover employers with 1 or more. That change actually came about in the area of domestic workers, who oftentimes may have been the sole employee of somebody who they were either taking care of their children or providing some type of care or services in the home. And unfortunately, there were a number of cases and complaints coming in the area of sexual harassment. And the legislature saw fit to add or to amend the law so that if you have 1 or more employees, you're covered as an employer. We also cover interns. They're also covered as employees under the law. So again, broad protections here are available. When we're talking about employment cases, you know, part of the investigation requires that the individual be qualified, right? So applying for a job, you were denied the job. I think it was because of my disability. You know, when we look at the resume, when we look at the qualifications of the candidates, that's all going to come into play in terms of determining whether or not discrimination took place. So you have to be qualified for the position in which you're applying for, qualified for the promotion that you may be seeking. And if you are, and the determination was made based on disability, that's unlawful, and that's something we can remedy. A lot of times I get asked, well, how can I prove it? And it's not your job to prove it. If you think that you were denied a job opportunity that you were qualified for, or a promotion that you were qualified for, and you think it may have been because of your disability, I encourage people to file complaints, because our investigators can get to the bottom of things by requiring information, demanding information. They can even subpoena some information if necessary. So we have some really broad powers at our disposal to conduct these investigations and get to the bottom of what happened. We talk about essential functions here. Essential functions are an important phrase in our law, and those are defined as those that are fundamental to the position. So what's prohibited in employment? Well, you can't refuse to hire or interview or promote on account of disability, fairly straightforward. Can't terminate on account of disability, straightforward. But it also extends to the compensation terms and conditions of your employment. So it doesn't have to rise to the level of a termination or the denial of an employment opportunity. It can be that in some way, shape, or form, the conditions of your employment have been diminished. The terms, compensation have been diminished, all because of disability. That is unlawful. And again, there's broad application of the law in that context. Employers are also prohibited from inquiring about an employee's or job applicant's disability unless that employee has made a request for reasonable accommodation. I'm going to talk about that in a moment. And again, we covered this earlier, but I just want to emphasize again, employers are prohibited from retaliating against an individual because they filed a New York State human rights law complaint or they're a participant to the complaint. So just want to emphasize that part. We mentioned reasonable accommodation earlier. I want to take you through the wording here in our statute. It says it shall be an unlawful discriminatory practice for an employer to refuse to provide a reasonable accommodation to the known disabilities or pregnancy-related conditions. That's italicized. That was added last year as well to cover people who need accommodations due to a pregnancy of an employee or prospective employee in connection with the job or occupation sought, provided, however, that such actions do not impose an undue hardship. So let's take that apart a little bit. So it says it's unlawful for an employer to refuse. So in order for there to be a refusal, what does there need to be? There needs to be a request. And the law is not designed to make employers to be mind readers. So if you're working with people with disabilities, if you are a person with a disability, and maybe you're falling behind on the job and it's related to your disability, you're not doing the functions that are necessary to do a good job, and that's because of your disability, you are entitled to reasonable accommodations to assist you with doing the functions of your job. If you do not make the request and your disability is not a visible one, those rights don't attach. So we've had cases where, you know, an employer will tell an employee, you know, I'm putting you on probation. You have 30 days to improve the quality of your work or to stop showing up late or whatever it is. And the 30 days comes and goes, an employee does not raise issues with regard to a disability or treatment maybe he or she is seeking or getting for that disability. You know, holding an employer responsible for something that he or she has no knowledge of is not something the law is designed to do. So we encourage people to speak to their, hopefully an HR manager who will know what the requirements are, to ask for an accommodation and then to have that process move forward. This talks about prospective employees. So if you're applying for a job and you need an accommodation in the application process, that's also considered a requirement under our law. And again, the analysis is whether or not the accommodation is reasonable, comes down to whether or not it creates an undue hardship. And that's very much a fact-by-fact or case-by-case basis. Typically, it's the cost or the nature of the accommodation versus what are the resources of that employer to meet the request. Some examples of reasonable accommodation can be making a work site accessible. There's a lot of assistive technology that's available now for people to use computers, to use telephones, to interact and communicate. It can also include providing support services for persons with hearing or vision impairments, and restructuring a job and modifying work schedules are all examples of reasonable accommodation. Remember, reasonable accommodation is not designed to eliminate functions of your job. It's not designed for you to cherry pick which you'd like to do and which you wouldn't like to do. It's designed to assist you to do the functions of the job as it exists. So what happens when we're talking about the interactive process, right? So there are obligations on both the employer and the employee to be interactive when we're talking about the reasonable accommodation process, which is a good thing. Hopefully that keeps you from having to file a complaint if you're able to work with your employer and get to an effective means of accommodation to keep and do your job. So the employer has obligations. One of them is to move forward with to consider the accommodation once the request has been made. So not sitting unduly, unnecessarily for a long period of time and not giving a decision. That can be a problem. And once that accommodation is under consideration, that employer does have the right to medical information to verify both the existence of the disability and the need for the accommodation to help them to do their job. Employers are obligated to keep that information confidential. But again, if you're working with people with disabilities, if you are a person with a disability and you're requesting an accommodation, it's fair game for an employer to ask for medical documentation to support the fact that you have a disability and to support the need for the accommodation. The employer has the right to select which accommodation will be provided so long as it's effective. And that is a big part of our investigations. You know, employer may say, well, I'll offer you this as an accommodation, but we make a finding that that wasn't really effective in allowing this individual to do their job. So that wasn't meeting your obligation under the law. And we can hold the employers liable for that. On the other side of it, we've had employees who have been offered an accommodation that is effective, but they don't want that accommodation. They want something else that's more, you know, suited to their preferences. And our regulations provide the employer with the right and the discretion to select the accommodation, but again, so long as it's effective in meeting the need. An employee, so the process is interactive. Both the employer and the employee are involved in this. Employee, again, has the obligation to make the disability and need for accommodation known to the employer. They have the right to request the accommodation at any time. And, you know, they need to cooperate with the employer too in the consideration or implementation of the reasonable accommodation request. It can't be, I want this and I'll settle for nothing else. Again, there's interaction, have to be agreeable, considering and perhaps even agreeing to an accommodation that's proffered by your employer. Again, so long as it's effective in getting the job done. Danny, here again, I'm going to stop before I move on to housing and see if there are any questions with regard to employment.
Everyone could unmute themselves if you have a question. I'm checking the chat room here. And the question is, will reasonable accommodations with regards to housing for people with disabilities be covered as well?
Yep, that's what's coming up next.
Danny, is it possible to ask people to unmute, to mute themselves again, unless they're speaking?
Yep. What I'm going to do is I'm going to try to mute everyone, and then I will try to unmute John so he can continue. So I'm going to mute everyone now, unless does anyone have any questions before John moves on, before I mute everyone? Okay, I'm going to mute everyone, and then John, I will unmute you and you should be good to go. All right. Give me
Okay.
1 second.
Yep. Moving along. So housing, broad coverage of housing. I mentioned earlier that employment is the #1 area we see complaints. Housing comes in solidly at #2. And over 60% of the complaints that we get at the Division of Human Rights include allegations of discrimination based on disability against housing providers. So a real significant majority and volume of the cases we see in housing are coming in under the guise of disability discrimination. You'll see here we cover both private and public assisted housing, rentals, co-ops, condos, single family homes, land and commercial space, and real estate agents. They are also covered. They are prohibited from discriminating against individuals based on their disability when they're providing services to assist people to find housing. This is a big change to our law. Source of income discrimination is now prohibited statewide. Previously, when I was doing presentations around the state and I was asked about source of income discrimination, I had to ask which county are we talking about, because it was a county by county basis. But now the entire state does have this prohibition against source of income discrimination. So what is source of income discrimination? Well, it's not unlawful for a landlord to ask about income. You know, how are you going to be able to pay the rent? What are the sources you're going to use? What is unlawful is for a housing provider then to say, you know, I don't want to take you as a tenant. You are going to use a Section 8 voucher. Or I don't want you to be my tenant because you rely on Social Security disability or HASA or some other form of income, maybe some type of public benefit income. And therefore, I'm not going to allow you to apply for or get this housing. That type of conduct is unlawful, and we can now investigate and prosecute complaints on that basis. So what's prohibited? Housing providers can't refuse to sell or rent or lease on account of disability, pretty straightforward. Also, similar to employment, it's unlawful for housing providers to discriminate against individuals because of a disability in the terms, conditions, or privileges of the rental or lease or sale. So what does that mean? It means similarly, it doesn't have to rise to the level of an eviction or rise to the level of a denial of a housing opportunity. We sometimes see these type cases in refusal to repair, refusal to provide heat and hot water. You know, those types of terms or conditions can be unlawful if they are being undertaken to discriminate against somebody because of their disability. So to give you an example of that, one of the tools our investigators have is to gather comparative data in housing cases. What does that mean? It means that they can interview other residents who reside on that premises. So let's say it's a heat and hot water case. So we get a complaint, somebody alleging my landlord hasn't provided me with heat or hot water. We check with the other tenants. Nobody's getting heat or hot water. So this is a bad landlord all the way around. It's not necessarily a landlord who's discriminating, but it's a landlord who's not living up to his or her standards as a landlord. So it may not be discrimination under our law, but for a different agency to take a look into. On the flip side of that, we may interview other tenants and they say, no, we've had no problems with our heat or hot water. But we find that the family, the complainant, has a child living with autism or some other type of disability, and the landlord is you know, withholding heat or hot water, withholding repairs as a means to hopefully get that family to move out. That's unlawful in terms and conditions of one's housing to discriminate in that way. Landlords, housing providers, they can't advertise or publish any form of application for the purchase or rental in a way that would be discriminatory. Landlords are allowed to have applications, you know, for people to fill out for renting or for purchasing, but they're not allowed to ask about disability. They're not allowed to ask questions related to disability, like list any medications you're taking or provide any information about family history or mental illness or physical illness. All of those are prohibited under the law. And this is an area actually our division initiated investigations unit can be helpful. So if you're working with housing providers or landlords and you get, an application ends up in your hands and it says list any medications or is otherwise asking about medical conditions, that'd be something we'd want to know about, because the likelihood of that application being in one person's hands is it's going to be in a number of people's hands. And that might be something we'd want to undertake a division initiated investigation on. So reasonable modifications. So yes, similar to employment, not only is it unlawful to deny housing or evict somebody from their housing because of a disability, but there's also an affirmative obligation on housing providers to make modifications to premises to make them accessible and usable for people with disabilities. So again, I'm going to take you through the language in the statute here in the first bullet. And it says housing providers must permit, at the expense of a person with a disability, for reasonable modifications of existing premises occupied or to be occupied by such persons if the modifications are necessary for full enjoyment of the premises. So let's break that down a bit. Again, the unlawful part of this is a refusal. So we have to have a request for permission. Now, this next part, at the expense of a person with a disability, that applies to interior of individuals' apartments or units. I'm going to talk about a distinction in the next slide about who pays for what and where. But if it's the interior of your unit, it's the kitchen or the bathroom or something on the inside of the unit you want to make accessible, landlord cannot refuse you permission to do that, but it's going to be on your dime. You're going to have to be able to pay for those modifications. We are talking about existing premises. A lot of times we have landlords say, oh, my building is grandfathered in. It was built before your law, so we don't have to do these things. And that's untrue. The language in the statute says existing premises. If your premises exists, you're going to be covered. And it talks about premises that are occupied or to be occupied. So maybe you're you filled out your application, you're ready to move in, but you need some modifications to be done to make the apartment accessible. You can ask your landlord to start to start that process. So it's both for places that are occupied and places that are to be occupied by said person. And then the last part of the statute is also very important. It talks about if the modifications are necessary for full enjoyment of the premises. And we take that full enjoyment phrase very seriously. We see these in ramp cases from time to time where somebody will ask their landlord to have a ramp installed so they can get in and out of their apartment building. And landlord will respond, well, we have a ramp. So we will send our investigators out oftentimes to do site visits. And during the course of the site visit, they will find a ramp, but maybe it's a ramp that's behind the building. It's used for all the garbage and, not for getting in and out of the building at all, but really just for, garbage and repair and that type of thing. That's not full enjoyment of the premises. Full enjoyment would mean getting in and out of the front of entrance of the apartment, just like everybody else is. So that phrasing in the statute is helpful to accomplish that. You'll also see that there's a requirement in rentals where a landlord can ask a tenant to restore the unit to its original condition. We sometimes see these in cases that involve roll-in showers. Somebody needs a roll-in shower. And in a rental case, the landlord is allowed, this is under both our law and the federal law, to ask the tenant to restore the unit to its original condition upon leaving. We talked about some of these examples: widening doorways, adjusting a kitchen or bathroom to make it accessible. Installation of grab bars are also structural modifications. So in 2010, the human rights law was amended to require housing providers to pay for reasonable modifications in common areas. So big question our investigators have is, okay, where are we talking about? Are we talking about the interior of your unit? If the answer is yes, the person with a disability has to be able to pay for those modifications. However, if we're talking about the front entrance to the apartment building or another area that's commonly used, and maybe laundry facilities or recreational facilities that is commonly used by the residents of that premises, landlord can be required to pay for those modifications, again, so long as it's reasonable. We're not in the business of bankrupting landlords, but the burden is on the landlord to demonstrate that it's an undue burden and will have to demonstrate that they don't have the resources to pay for the modification. And that analysis is undertaken when we're trying to determine whether or not the accommodation is reasonable. But again, if you're talking about a modification to a common area, landlord can be responsible for paying for those modifications. Here is the other section of the law that speaks to reasonable accommodations. And here we're talking about rules, policies, practices, or services. So it's not only limited to structural modifications, but it could be a rule, right? Waiving a no pet policy for somebody who needs an emotional support animal would be considered a form of a reasonable accommodation. And we're going to talk about some examples here. So now a reasonable accommodation includes installation of a ramp in a common area because the person with a disability doesn't have to pay for that. I mentioned waiving a no pet policy for a person with a disability who needs an emotional support animal, and we're going to get into that in a bit more. Also parking. So somebody who needs a parking space may be adjacent to their unit so that they can get back and forth easily because of a disability, a mobility impairment. Providing somebody with that parking space or putting them up to the top of a waiting list. You know, if all the parking spaces are taken, putting that individual at the top of a waiting list to get a parking space that's close by and on an accessible route would be something also considered to be a form of a reasonable accommodation. So let's talk about guide, hearing, and service dogs, emotional support animals. So this section of the statute is very strong for people that have a professionally trained guide dog, okay, or a hearing dog, persons who are deaf or hard of hearing. You know, the dog alerts them to maybe a doorbell or a fire alarm, something that's auditory. And then lastly, a service dog. There are a lot of different types of services dogs can be trained to do for a variety of disabilities, some of which include autism or seizure disorder. There's a lot of medical literature out there that support the services that dogs and animals can provide for people with disabilities to improve the quality of their lives and diminish the impact of the disability. You'll note here that the word is dog, but essentially if we're talking about a guide dog or a dog that's been professionally trained to accommodate a person's disability, that dog goes where the person goes. And that's a specific section in our statute that speaks to dogs. We are not limited, however, to dogs when it comes to housing. In housing emotional support animals. So it could be a cat. You know, as we get more and more exotic in the type of animal we're talking about, we may be getting further and further away from the reasonable standard. So, and there's also a requirement that a medical provider, prescribe or recommend and document the need for the emotional support animal. But persons with a disability that have a disability-related need for an emotional support animal can also ask a landlord to waive a no pet policy to allow for that emotional support animal to live with the individual. So again, this is not just somebody who has a disability and likes dogs or cats. It has to be that the animal is providing an accommodation, something that's disability, medically related to their disability, to accommodate them. And a landlord is entitled to medical documentation to support that the person has a disability and that the need for the animal is disability related. People get confused about this requirement and the requirement that exists for places of public accommodation. So I oftentimes ask people, where am I standing? If I'm standing in my home, I can have an emotional support animal, but my landlord's entitled to medical documentation that supports the fact that I have a disability and supports the fact that the need for the animal is disability related. If I'm going out with my service dog out into the public, business owners can only ask two questions. Is it a service animal, and what kind of service animal, and what kind of service does the animal provide? And that's it. So that's a distinction between housing and places of public accommodations to understand. And landlords are also prohibited from making restrictions on the type of animal, the breed or size, or assessing fees for someone who needs an emotional support animal because of their disability. This also would apply for persons who need guide, hearing, or service dogs. So, you know, landlords are allowed to have pet policies. They're allowed to have no pet policies. And in their pet policy, it may be you're allowed to have a dog, but it can only be these types of breeds, or it has to be smaller than 20 pounds. But that's all lawful. However, if you move in or you live there and you have a disability and you have a disability related need for the animal and it's animal is larger than 20 pounds, or maybe is not necessarily the breed that is on their list, landlords cannot impose those requirements. It's unlawful to do that. Nor can they assess fees. They may assess fees for pets, but remember, emotional support animals, guide, hearing, and service dogs are not pets. They are animals there to provide service and accommodate people with disabilities. So again, an important distinction to be made there when we're talking about emotional support animals, guide, hearing, and service dogs. With housing, I just want to wrap up with some new construction requirements. So if you see a new apartment building or dwelling going up that includes 3 or more units, or something that has been built after March 13 of 1991, which is not so new anymore, obviously, those units, those dwellings have to be built in a way that's accessible for people with disabilities. And oops, jumped too fast there. And typically those requirements apply to entrances, widths of doorways, no steps at the ground floor level, usable areas in the apartment, having light switches and different environmental controls in areas where people who use wheelchairs can reach them, providing backing in showers and bathrooms for grab bars. Those are some of the design and construction requirements for something that's built new. This also would be an area where our division initiated investigations unit would be interested in looking at. If you see a big new development going up in your neighborhood and there's a step to each of the ground floor entrances, that's going to be a real signal that not only is the step a problem, but there's probably a whole host of other problems with the dwelling. So that might be something our agency may want to take a look at from a division initiated investigation point of view. Danny, I'm going to open it up again to questions here for housing before I wrap up with public accommodations.
Sure. So once again, if anyone has any questions, you can unmute yourself and then ask them. I'm in the chat here, and there is one question, and it seems like there needs to be the person's looking for some clarity in regard to state versus city law. So let me just read the question. Sure. When does a landlord fulfill his duty of reasonable accommodation absent undue hardship? With regards to home modifications, I believe state law makes disabled tenants liable for costs, while city law places the burden on the landlord. Same question, but with regard to providing reasonable accommodations to relocate to accessible units.
Right. So let's take the first part of that question. So yes, New York City has a very strong human rights law. I'm only going to speak to the state requirements because I'm not an expert on the city requirements. So the state, when it comes to paying for paying for reasonable accommodations to modify one's home to make it accessible, the question that needs to be answered per the state law is, where are we talking about? If we're talking about the interior of one's unit, there the person with a disability has to be able to pay for those modifications. If we're talking about a common area under state law, okay, under New York state law, not under the Federal Fair Housing Act. Federal Fair Housing Act does not have this distinction that the state human rights law has. So if you're talking about a common area, making that area accessible for somebody, and it's reasonable to do so, a landlord can be obligated to pay for those modifications. My understanding, and I'm just going to leave it at this, my understanding is that the city human rights law also places obligations to pay for modifications on landlords, but I'm not so sure if that extends to interior or not, and I don't want to necessarily give out bad information on that. So you may want to reach out to the local City Human Rights Commission folks to get clarity on that, but I can certainly speak to the state human rights law part of it there. And then Danny, was there a second part to that question? I'm sorry.
Yeah, let me scroll back up. Same question, but with regards to providing reasonable accommodations to relocate to accessible units.
Yeah, so that can also be a form of accommodation. It would have to be a unit that's available. We wouldn't be talking necessarily about moving some, if somebody was in the ground floor unit, moving them out. But if a landlord had housing stock that included accessible units, transferring somebody to that unit could be a form of a reasonable accommodation. Yes, indeed.
Okay. Have another question here in the chat. It's how is the Division of Human Rights assuring that persons with disabilities are fairly treated with regard to affordable housing lotteries? I have witnessed firsthand, along with others who are wheelchair or bedbound, who have been selected log number, and when they hear they are disabled, the unit has suddenly been filled.
Yeah, I mean, in those instances, if somebody's been denied a housing opportunity that they're otherwise qualified for, merely because of a disability, that should be a complaint that gets filed with our agency. So, you know, again, if somebody is maybe on a list, or whether it's lottery or some other type of eligibility list, a waiting list, and they've been denied a housing accommodation because of their disability, that should be something that a complaint gets filed on that we can investigate.
Yeah. And so we can open it up to anyone who wants to ask verbally. Any questions?
Please.
Once again, you have to unmute yourself.
Yes, Yolanda,
Hi,
I
Ilana.
would like to ask, what exactly is dwelling?
Dwelling is very generously defined. It's defined as a space that's intended for sleeping. So it could be a shelter. There are some limited exclusions, like rooming, boarding homes. If it's a two-family house and the landlord owns and resides in one of the two families, there are some limited exemptions there. But if it's an area, if a dwelling is an area that's intended to be used for housing, intended to be slept in, again, very broad definition of dwelling in that capacity. If you want to speak to me, individually about certain details, you're not so sure if it's considered a dwelling or not, I'm happy to do that. But dwelling is very broadly defined under the statute.
Thanks, John. Any other questions? I see a couple of things just came in.
Sure.
Okay, no, I think we're good to go.
Okay. Okay, so we're going to finish up with places of public accommodation. So these are, again, broadly defined places that are open to the public. We're talking about hotels, restaurants, stores, parks, hospitals, medical offices. So healthcare facilities, very importantly, are covered under this section of the statute, along with a number of other public entities. Also important to note that state and local government entities are also included and considered to be places of public accommodation. So what are the protections in this area? Well, you can't be denied services or goods on account of an individual's disability. You can't be denied those services or goods. And also, in addition, similar to what we've been talking about, this is always a common theme in civil rights for people with disabilities, is the obligation to affirmatively make reasonable modifications. So it can be modifying a policy or a practice or a procedure when those types of modifications are necessary to allow people with disabilities access to goods or services. Some examples could be making sure staff are trained to assist people with disabilities to access goods or services. We have a lot of curbside service and home delivery of goods going on right now with the pandemic going on, but that also is a fairly typical form of reasonable accommodation for somebody with a disability to make sure that they have access to goods or services. I want to add that websites now, under state and federal cases, websites now are considered to be places of public accommodation. There was a decision recently under the state human rights law that clearly included websites. So being able to access and use somebody's website in a way that's accessible, they're covered as a public accommodation space. So there's also an obligation to ensure that people with disabilities are not excluded because they've been denied an auxiliary aid or service. And what we're talking about in terms of auxiliary aids or services, examples would be sign language interpreters, captioning can be an example, providing materials in alternative format. And again, there's just a tremendous amount of assistive technology that's available, video relay service, different types of technology that really allows for people with disabilities to interact, to access goods and services, and to be involved in what's going on in their communities. So denying somebody, sometimes we see these cases, unfortunately, in the healthcare setting where healthcare professionals somebody will say, I need to have a sign language interpreter available when I come in for my appointment. And having a healthcare provider deny that request is unlawful. There has to be a request. It's unlawful to refuse these accommodations. But once that request is made, those individuals, those places that provide services to the public have to do what's reasonable in order to accommodate people with disabilities so they can access those goods or services. There's also an obligation to remove architectural barriers. So, you know, you want to be able to get into your dentist's office or a restaurant, someplace that's maybe newly opened. It doesn't have to be newly opened. And there's a step or the bathroom is not accessible. Asking a business owner to remove a architectural barrier in order to make the premises accessible is something that's also required by law. And the standard there is readily achievable. You see there in the slide, it talks about places of public accommodation must remove architectural barriers where it's readily achievable to do so. That means, and before I get to guide hearing and service dogs, that standard is what we're looking at is what is the cost of the modification, what is the cost of installing the ramp versus what are the resources of this particular business. And that's what we're looking at when we're looking to assess whether or not it's readily achievable to make premises accessible. So in both, well, employment as well, but places of public accommodation also are obligated or prohibited, I should say, from denying somebody with a disability entrance or access to goods or services because they have a service dog with them. And our requirements are identical to what the Americans with Disabilities Act requires for places of public accommodation and the phrasing in both statute is service animal. The definition of animal is limited to dogs and miniature horses. Believe it or not, miniature horses are covered. I've been doing civil rights work for people with disabilities for 25 years, and it took a while to understand why miniature horses, but have been recently educated that miniature horses live a lot longer than dogs do. And while I haven't necessarily seen the miniature horse in action downstate, I understand upstate, maybe they're a little more prevalent. But the idea there is that they live longer. So somebody, let's say somebody who's blind that's using the miniature horse to guide them around versus a dog, you know, if you have a dog and the dog only lives a certain amount of years, introducing a new dog, all the training that is associated with somebody who's blind, who needs a guide dog to keep them safe when they're out and about, you may go through a number of guide dogs in the course of your life, which can be challenging. Miniature horses live a lot longer, so and oftentimes they're smaller than dogs. So they're included under both the ADA and the New York State Human Rights Law. So dogs and miniature horses, so no service cats or service monkeys, it's dogs and miniature horses. And it does not extend to emotional support. So, you know, again, business owners are allowed to ask two questions. Is this a service animal? Yes, it is. What kind of service does it provide? Well, this is my emotional support dog. Emotional support is not covered by either law, so it has to be a service dog. A lot of times I get asked, what's the difference between emotional support and service? Typically, the answer is that the dog has been trained to do something. A really good example of this, we did a program up in Rochester, and we had a veteran who was giving a presentation, and that veteran was living with PTSD. And the veteran had a dog, a service dog, that had been trained to do two things. One, to be alert to the manifestations of the PTSD symptoms. So he said his voice would go up, he would get very rigid. If it was being triggered by something, the dog was trained to be alert to that manifestation in his tone or his behavior. And then the dog was trained to do figure eights in between the legs of this veteran. And that calmed him down. It diminished the effects of the PTSD. It got his mind off of whatever was triggering it. And he was able to take a breath and not go into any kind of really full-blown problem. So there, although somebody may say, well, that's emotional support, you know, he's calming himself down. Not so. This is, while that may be true as a fact, but this dog is not merely emotional support. This dog has been trained to do these things. So that's something our investigators are looking at when we're talking about access to public accommodations and animals. What type of service, you know, is it a dog or a miniature horse? First, if the answer to those questions is yes, what is the service being provided? If it's emotional support, not so in public accommodations. Don't get this confused with what I said earlier about housing, right? Where am I standing? If I'm standing in my home, an emotional support animal is a perfectly fine example of a reasonable accommodation. Not the case if I'm going out to dinner or to a bank or someplace that's open to the public. There it has to be a service animal, dog or miniature horse, which has been trained to do something. So here, Margie, I was glad to hear you talking about the census. We include a slide in our presentations here too about the importance of making sure you get counted, and also some information about how to go about that. The 2020 census website is there, www.ny.gov/census. And the respond online is www.2020census.gov. That's there. So my contact information is also here. We have an email, which is a general email, info@dhr.ny.gov. You can reach us by telephone at 888-392-3644. My contact information is there as well. I'm probably checking emails more regularly than anything these days, but I do check in on my voicemails as well. But I'm happy to answer any questions that people have, or speak about the process if they want to file a complaint. We also have a social media presence. You can see our Twitter and Instagram accounts here, Facebook, LinkedIn, etc. And we have a newsletter. You can sign up by emailing newsletter@dhr.ny.gov. And we have a newsletter that is shared periodically that provides updates about our agency's work or updates about the law. So Danny, I think that is my last slide. And again, I'm happy to open up to any questions.
Can I just quickly add something?
Sure.
Just in terms of the census has several ways that you can get help by phone, online, etc. But our understanding is for some folks who need a little extra time, or who need a little extra help in one way or another, the census people who are answering the phones and such aren't always as accommodating as they might be. So I would encourage you, if you have either questions or want help with the form, to reach out to us. We're happy to help you figure out the best way for you to do it, and even walk you through the form, etc.
Terrific.
Thanks. And Margie, you had a question about remote events. You had mentioned in the chat.
Yeah, I think John answered it. Just that even in terms of entertainment or other public events that are now online, are they covered? Or?
So yeah, so websites would be covered. The case that was decided was about a website for a business owner. I think the most important thing is getting that request made out front. And of course, if you're in the business of providing information, to people with disabilities, you want to be thinking affirmatively as to what you can do to make it fully accessible. But I would say right now, if it's being done vis-a-vis a website, websites are considered to be places of public accommodation. They have obligations to ensure that they're accessible. Now, it's usually kind of a two-piece or two-way deal, because the developer of the website has to develop it in a way that's compatible with other accessibility. So the user sometimes needs something on his or her end too, but the idea is to ensure that there's compatibility there if that's what's needed. If it's in terms of communication, similar to what we're doing today, captioning or providing American Sign Language interpretation, can also be ways of ensuring that whatever message is being conveyed is being done in an effective way to as broad an audience as possible.
Okay, great. Thanks so much, John. Any other questions? Once again, you have to unmute yourself. I just see a comment in the chat box. It says, thank you for taking the time to address our rights under state law. This refresher was much needed and appreciated. So I think pretty much everyone would chime in and echo those sentiments. Definitely much appreciated from ICS for both Margie and what Sydney's doing, and John, what you're doing, and what the Human Rights Department is doing as well. So any other questions?
No, Danny, I just want to say thank you, for this presentation. was really good for all ICS workers, for the community, of course.
You're welcome. I appreciate you sharing that. I know I used to work with a lot of the ICS staff there, so I have a great admiration for the work that they continue to do.
Yeah. And we have members that are also, they work for us as well. So this helps them on a personal level as well as a professional level. And I know a lot of people on this call are advocates, so they can use this in ways to support themselves and others. So it's of great use.
Very good.
Pleasure to be working with you all, and I'm glad to see everybody, or everybody's image somehow.
Okay, so if there's no other questions, once again, we will be getting out this recording as well as the presentation slides, the material from CIDNY. Just give us a few days as we download the recording and get that on our website. And if you have not RSVP'd for this event to Christy Cruz, I suggest you do so. That way we can make sure that you get all the material. Christy's email address is christy.cruz@icsny.org. Once again, that's christy.cruz@icsny.org. Okay, so if that's it, once again, thanks everyone, and I'm sure we'll be crossing paths again soon.
Very good. Thank you,
All
Danny.
right.
Thank you.
Thank
Thank
you.
you very much.
Bye-bye.
Thank you.
Thank you, everybody.
Thank you. Good night, guys. Good night.
Okay.
Good night.
Bye-bye.
Be safe.